So we have Cynthia, Rich, Jessica, and Chad. So we're just missing Luke and Alex. And then everyone on ZBA. We have three of the attorneys from our town attorney's office, Bertram Moses, here to speak with you all tonight on just some general ZBA topics.
Should I
Hey,
start it?
And
hello.
to answer any questions.
Yes, and to answer some questions.
Yeah. Good evening, everyone. I'm Ira Bloom. Pete Gelderman is here, Nick Lamonte, all from the firm Bertram Moses. We wanted to bring all three of us here, so you can sort of see us all and ask us all questions, and we want to participate in this. So thank you for setting this up, Sarah. And we're going to try to. I mean, there's no precise time limit from our perspective, but we do this quite a bit, and a good hour usually does it. It allows time for questions. We can go over if you still have more questions. Um, I don't think typically if there's a question, just kind of interrupt one of us and ask a question. I think we can handle it that way with a small group. If it gets so unruly, then maybe we'll hold the questions to the end. But usually it works if we just kind of if you have something you want to ask at the moment, just flag us, just say something. We'll stop. We've got several things to cover. I'm going to start with um, some basic stuff about zoning boards of appeals and hardship and all that. We're going to talk about a couple of the more relevant and fairly recent, not brand new, but fairly recent cases that are important to know, particularly this E and F case that we'll talk about in Varillo. We're going to talk about decreasing nonconformities as another ground, and also appeals from actions, decisions of the zoning enforcement officer, the zoning official. And we're going to add a little bit about bias and predetermination and conflict, just because that those are topics that also come up. So it's sort of a lot to cover, but we can try to get through it. Let me just start off with some of the basics here, and presumably you know all this, but we'll go through it kind of orderly here. You know that your powers are derived from the state statute, so you're empowered to hear and decide applications for variances of the zoning regulations. Very often, as you know, I'm sure they're dimensional kinds of things, um, coverage, setbacks, etc., height. You know all that. For variance to be granted, there are basically two conditions. One, the variance must be shown not to substantially affect the comprehensive zoning plan. That is not usually the subject of a lot of discussion, but it could be. It does have to. It is one of the conditions. The more important one that we talk about is that it must um, there must be the regulation must be shown to get a variance to cause undue hardship, and that is the source of a lot of your discussion, a lot of our discussion as to whether an undue hardship is shown. The hardship has to be unique to the property. I'm going to talk about that with a real world case that I had many years ago. Um, and Usually that means that there's some physical characteristic of the property that's different from other properties in the area. So, the classic case, when we used to talk about this before, a couple of these cases, the classic case would be someone that has, let's say, an unusually shaped property, so that they can't put their extension on a certain side because of the shape, and therefore they need a variance to go into the setback, let's say, on the other side. I mean, that's kind of your classic case. There's something about the physical characteristics of the property, either its shape, maybe there's wetlands. Those are the easiest cases to deal with, or at least they were. So that's kind of the easy part, which I'm sure you know about that. Not all the cases are quite that easy. The applicant does have the burden of proving it, so they need to stand up and at the hearing and explain to you what the particular hardship is, and how it affects their property and how it's unique. in our land use world, we say to each other and to you that there are very few true hardships, actually. The example I gave you, might be the closest you'll get. It doesn't come up that often, but people, they'll talk about, well, I got a small lot or something like that. And if it's a convincing case and they articulate some hardship, they will often get it. The percentage of granted variances, I don't have an actual number, but in most communities that we deal with, and I think statistically in the state, it's really quite high. And perhaps that's as it should be, because that's you're set up to offer those kinds of variances to allow people to do certain things under certain legal standards. That's what the public wants and expects. So we're not surprised about that, but there are limitations to it. We'll talk about that a little bit more.
Strong limitations, which
Strong, strong
I'm
limitations.
happy to slightly dip into, Ira, if you would like.
Yeah, let me just go through a little bit of this, and then we'll get to some of those cases, and we could talk about that. But I'm sort of still in the basic stuff here. Financial loss is not a hardship, so you can't say, well, it's going to cost me a lot of money or something like that. A monetary related one is typically not does not constitute hardship as a general proposition. I said it has to be unique. And I'll just tell you an example of a case that 28 years ago, when I was first appointed Westport town attorney, and I was handed a case. I wasn't at the hearing, but a hardship, a variance was granted. There was hardship. These were houses down at the Westport Beach, which are all very small. A lot of them do get variances, and one was granted for somebody in particular. And one of the factors was because of the small lot. Well, that did not turn out to be successful on appeal to the court, because the judge said, well, it's not unique. Every lot down there, in the whole area is small. So to say it's a small lot, therefore, we're going to get granted variance, the judge rejected that and overturned that. So, lesson learned, you do have to look around, and if everybody has the same particular size, as an example, that probably won't work. Self-created hardships, something that you've done to create this situation, should not be granted either. So those are, some of the traditional general limitations and rules and regulations. The ZBA should state its reasons on the record. That's important. In one of our towns, I won't name names at the moment, they would just say, they would, vote that it was granted, a reason, hardship, something like that. It was like a one word.
Topography or
Topography, a
lot
little
size.
better, but hardship show. Yeah, it was something. Yeah, maybe they were a little more specific, but I do recall judges saying in open court, basically, well, that's what kind of reason is that? You're going to force me to search the record, and I don't feel like doing that. I remember in one case, and we had to go back and articulate what the hardship was. So you really should state the reason. And so that any reviewing judge can see what it is. And similarly, if there's not a hardship shown, you should state why in that case also. And that's for the benefit of the judge. Basically, if there's any appeal, a lot of this is premised on if there's an appeal. If there's no appeal, then probably nobody's ever going to look at it. So I'll pass this on to one of you guys if you want to talk about E&F or Verillo, and then we've got to talk about appeals of the zoning official. So we can jump to what you said, Nick, or and Pete.
Yeah, Nick, you seemed
It
anxious.
was kind of an explosive case. Are we going to do that with E&F next?
Sure.
I think so, yeah.
Yeah, I mean, it fits right in here, and looking for the citation here. It's in the materials. All of what I'm saying is in that memo that we provided earlier. And E&F, I'm looking for the citation, but it came out in 16 or
2015.
15 was the ENF case, and thanks, Ira, Pete. The bottom line out of this ENF case that came out close to 10 years ago now is that we cannot grant variances unless there is literally no economic value to the property unless we do. So that ties our hands in a lot of respects. This ENF case was a Dunkin' Donuts case that said, hey, we can make more money if we trump up our sales here. The town, will you let us do that? And ultimately, based on the zoning regulations, the town decided no, and the court said, well, you can only go so far to expand a non-conforming use that you already have. And what ENF said was, in this decision, if there's any sort of, if you can get some sort of economic value from the property as is, then the courts have no ability to say, no, town, I'm going to reverse you in denying this permit for an additional use. So what ENF says, long and short of it, is we cannot expand beyond a use that has already been at this property. So, I mean, the only way that you as a board, from our perspective at this point, the best way that you can grant a variance is if there is in the application a proposed reduction to a nonconformity of an existing zoning defect. So, I mean, Pete, I'm going to kick it to you to sort of drill down on that, but
yeah, I think we need to bring that
You know what?
down to.
Yeah, just talk a little bit,
Human
Nick,
terms.
first about ENF for a second. Because what ENF was a setback issue, not a use issue. Just it comes a lot to the same thing for the most part. But ENF wanted to build a second story above their initial store, and that the store, the first floor was within the setback, but it was legally non-conforming, and the second floor would have encroached into the setback. New Canaan, by the way, is a little different in that respect. You can go up in New Canaan within a setback because the regulations allow it, but in Fairfield, they didn't. And so, as Nick said, what the court said was, well, that's not necessary for you to have economic value in your property. You don't need that variance. Your property doesn't have to be the absolute highest and best possible use in terms of economics. So
In other words, it already had economic value. I think
it had
that's-
economic
it had
value.
economic value as it was, and therefore a variance should not be granted if it already has economic value. I
Right,
think that's
right.
the central point that we have to state.
That's
And-
right, because a vacant lot may be treated differently, but
Yeah, so let me just bring this to, let me try to reframe it. When we saw that case, it was kind of startling. And a lot of us in the land use world said, what does this mean? Suppose someone comes to you and they have, I'll say, a modest 3-bedroom house Okay, I get it, you know, in New Canaan, maybe that doesn't happen too often, but let's use that for an example. A modest house, and the person says, you know, I want to add an addition here, and I'm in the setback, but I've got a reason, and maybe it's the shape or the wetlands or whatever. If you follow this case from 2015, because that 3-bedroom house already has value, it's worth something. Somebody's living there. It's a house. It's a small house, but it's a house. Then really the variance should not be granted. So it added that economic development factor, which we didn't have to look at necessarily quite like that.
Yeah, I'm sorry to interrupt you, but I mean, I think this is a very, very important point, Jessica and Cynthia, and I, you know, because that, as you said, and I read your memo, you know, I think one of our most common situations is where you have, you know, a residential dwelling and they can't, you know, extend on one side because of a septic, wetlands, and then they, you know, would want to go on the other side and they infringe on the setback and they argue that the hardship is because their property is a little smaller and it, you know, and they have, you know, the wetlands in a septic or propane tank and you know, so yeah, this is pretty key for us because you know, we see this all the time, and I tend to say I think we, you know, we view it as sort of, you know, we've come out favorable to the homeowner, you know, a lot of the times in the past, so that this is important for us to note this point right here.
Yeah, and so that's why this was, you know, kind of change the rules, we thought. In reality, over a 9 or 10 year period, I don't think it's changed that much. But the case is out there. But, you know, to use your example, it doesn't have to be a 3-bedroom house. It could be a 6-bedroom house, but the person still comes in and says, I can't build here because I got, you know, ledge, I got whatever, the shape, so I want to build over here. Under the CNF case, there could be an argument that, well, that house was perfectly fine. In fact, beautiful. I'm sure 6 bedrooms and all that has economic value, very high economic value, I guess. And therefore, that case would say you shouldn't grant that variance just because of that. And that was a different approach. It remains the law in the state. And however, I think we have to tell you that our observation in multiple towns is that it's often just put aside. And, you know, back to that case, if there seems to be a hardship as we used to define it, and it seems like the fair thing to do, and if there's no neighbors objecting in particular, then it gets granted. So I haven't seen, I don't think we have seen any great diminution across the board in variances. And so I don't want you to take this and say, oh my God, we've got to go from granting 75% to, 1%. That hasn't been the pattern that we've seen. But we have to tell you that case still is out there. And there are some lawyers that would raise it on behalf of an opposing neighbor, and they would raise it to the judge. And so that case is out there. You guys have anything more to say about that?
I see you, Jessica. Jessica.
Yeah, no, so just a quick question, because it is about almost a decade old, that case. Has anyone tried in the courts to try to limit the application to just commercial properties? Since the economic value in that case facts was really based on the fact that they had prior offers and then wanted to kind of expand it in a new property way. So I'm just wondering if there's been any way to kind of skirt it that way as far as application of residential.
That argument, to my knowledge, Jessica, hasn't been made. And certainly I've seen a lot of cases of residential variances where it's been applied. So it's possible that it could be changed on a legislative level, but the courts have not carved out an exception for residential property yet.
It was a case in Fairfield. Attorney Joel Green, whom some of you know, does quite a bit of work, an excellent lawyer, was the lawyer in that case. It, you know, it's out there, and as long as we're aware of it, and I mean, Pete and I were at the Westport ZBA doing the same kind of session shortly after the case came down, and we you know, described it, and I'll never forget. I mean, the chairman, he's still the chair. He was like, he was almost angry at us, I think, for bringing it up, and you know, and said, we got to take a break. And so they walked out in a little bit of a huff, because they didn't like what we were reporting. But with the benefit of, you know, several years now, it you know, it's just part of the territory now. It's out there. It as far as we, you know, it remains good law. I don't think many of the commissions that we deal with have taken it literally. But sometimes they get overturned.
And the case of ENF expressly in its language overruled the case that used to apply to variances, which is called the Stillman case, Stillman. I don't have the site here, but the Stillman case was the case that Ira was describing, basically, where somebody wanted to put an addition on the side of their house. That addition would have gone into the setback, but they had wetlands and ledge and their septic system all on the other side of the house and behind it. So it was the only spot on the lot where an addition could actually be located from a physical point of view. That Stillman case said, yeah, that's a classic hardship. That's what we're talking about with a hardship. That was in the 80s. That stayed that way until 2015. So, and there's, you know, there's some movement among certain members of the bar, at least, to try to come back to something similar to that through a legislative change, but that hasn't happened, and that may not happen. And but that's why ENF was such a, as Ira said, such a kind of a major, not just, I mean, it was a 180 almost from what the law had been up until that point. So it did surprise a lot of land use lawyers. It raised a lot of questions initially, but as Ira said, things haven't necessarily changed all that much as a practical matter in most towns, although the law has.
But I think the public still expects, you know, their local zoning board of appeals to, you know, to listen to them and grant their requests. So, you know, that has to be considered too. But the law obviously has to be followed. There has to be a hardship. This case remains background. You know, we go forward. That's the best we can say with the benefit of an existing case like that, and, you know, 9 or so years of people just trying to absorb it and deal with it.
And by the way, Ira, one quick point. ENF was a Supreme Court case. The other case you see highlighted on the first page of the memo is called Varillo. Varillo was an appellate court case, but Varillo also decided in 2015. All Varillo really did, it was about a 65 or 70 page opinion, if memory serves, and it really just sort of I guess, for lack of a better word, it just sort of went through the history of legislation and variances, and it came to the, you know, it was a conglomerate. It was a history of how variances were treated. So it didn't make any new law necessarily, but it's just an interesting case. If you ever feel like reading a case that gives you a lot of information about variances in the state of the law today, you'd find it in Varillo. I just say don't do it if you're tired, because you'll fall asleep. But anyway.
So if there are no more questions on that case, let's talk about, you know, the other main role of the ZBA, which is to review upon appeal, review decisions of the town's zoning officials, the ZEO, or whoever makes the decision. I'll hand that off to either one of you guys to talk about that. That is, I'm sure, something you get, moderately often, at least. Whatever. Nick,
Yeah.
you want to start with that, Pete? Any of us?
Well, you had one recently, and I listened in on the deliberations for that. So, the analysis in that was for the most part correct. It's a de novo kind of hearing. You look at all the facts, whether they were considered by the ZEO or not relevant to the case, and you make a determination whether the decision was proper or not. Now, the decision should be based on whether the regulations, in the case of the zoning permit being issued, the issue is whether the zoning permit should have been issued pursuant to the regulations. And that's kind of the limit of your consideration in something like that. There's other decisions that sometimes get appealed, not just zoning permits. I can tell you that a decision by the zoning enforcement officer, as you all know by now, not to enforce a violation is not an appealable decision. So it's always discretionary with the zoning enforcement officer, subject to whatever political pressures might be put upon him or her, to enforce the regulations as the ZEO.
Hold on, pause for a
sees fit.
sec though, Pete. No, that is completely right. But just to go back to a second to what can potentially be appealed, it's not necessarily a decision of the zoning enforcement officer to take some sort of zoning enforcement action. Let's say staff behind the desk rubber stamps a site plan. In that instance, that would still be appealable to this board that we're talking to right now, right?
Yeah, that's true. That's true. That's a decision.
So it doesn't necessarily have to be an enforcement decision, folks, is what we're saying. It can be just an affirmative if there's a behind the desk rubber stamping approval type event that staff does. That is an appealable event to your board.
Yeah, well, I think that's a distinction though from what Pete was saying in terms of enforcement or lack of enforcement, but it
Right.
is important
It
point.
is, it's
Sure.
another, but Nick's right, that's another appealable decision.
Right.
Or action by the ZEO or someone charged with the duties of the ZEO, or as Nick said, a staff person. So all those are appealable, and again, just like a variance, you need 4 votes. And that means 4 votes. It's a funny thing because the ZBA has a quorum with 3 people. But it can't vote on anything with 3 people. You need at least 4 people to vote. And if you're going to have a situation where only 4 people are voting, you ought to get the approval of the applicant, because it could prejudice the applicant if there's only 4 people voting. So the applicant should agree to that.
Yeah,
So
that's I think maybe an important point to keep in mind, because they got to get 4 out of 4 as opposed to 4 out of 5. So they ought to know that. I think in most cases, they'll ask for a postponement if you can't get 5 people. So those are the key points. De novo meaning from the beginning. So it's a full hearing, from the beginning. You make your own decision with a full review of the evidence, and so. But based on the regulations, it can't be an arbitrary kind of thing. There's one other side issue on that, which frankly does not come up too often, but I think it's worth noting. There are situations where, since you are reviewing the actions of the zoning official, I'll use names. Let's say it's something that Sarah had issued or signed. As an example, if our firm, if Nick or Pete or I had worked with her, had advised her, yes, I think you should issue this. It's maybe it's gray, but we advise her to issue it, and then that's appealed. You do have the option of getting your own counsel for that, since our firm, the regular town attorneys, have worked with Sarah, whose decision you are reviewing. Doesn't come up too often. I mean, in all my time, I've probably only seen it literally a handful of times over 28 years doing this kind of work, or longer even, arguably. So it doesn't happen too often, but once in a while it does. And I just wanted to leave that out there. I'm not encouraging, bringing in other attorneys if you don't need it. But there are some extreme situations, or maybe not extreme, but there are some situations where that would be something to think about. And you'd have to approach the town as to how to do it, but that's we could be in a conflict, in other words, having worked with Sarah to craft whatever she did, or help her make a decision on it. So something to think about. Trying to go through this here to come up with some of the key points here.
There is one option that the law has outlined separate from finding that there is a hardship.
Oh,
That
yeah,
the
we didn't
law-
do, I'm sorry. Yeah, okay, non-conforming. Sorry, I was coming to that, and I want to talk about the Anatra case too. So you want to talk about reduction of non-conformities?
Sure, I'll set the stage.
I thought that's what you're heading into.
Yeah, no, that's where we're going. So the like we have two options under the law. Either if there's a hardship, you can grant a variance. The other, more slippery option is if there's a reduction in a nonconformity, an existing nonconformity to the zoning regulations. And there's some nuances to how that works. If there is one existing nonconformity and you want to replace that with another, I'm going to kick that to you, Pete, to talk more about that. That's your wheelhouse. But this is another option that you as a ZBA can grant a variance, but they're fairly nuanced and precise findings you need at first to grant a variance on these grounds. Pete, you want to dive into that? You're
Thanks,
muted.
Nick. Thanks, Nick. Let me give you first an example of how this would work. Just an example. Somebody owns a house and they have the house encroaches into setbacks both in the rear and on the side, say. And the applicant wants to put a deck in the rear that would further encroach into the setback, or even if it didn't initially, it now encroaches into the setback. But they're going to take a staircase on the side of the house and get rid of it, where that staircase was in the setbacks. So they're going to reduce that encroachment into the setbacks on the side, but they're going to add an encroachment in the rear, but the net is less building in the setback. So you've reduced the nonconformity. And it's the same nonconformity, which is setbacks. If you wanted to take that porch off in exchange for letting someone go a couple feet higher, that is not a reduction in the same nonconformity. And the courts have held that, you can't trade off nonconformities. You don't get to reduce a setback in exchange for an increase in height. Because how do you measure if it's a reduction or not? How do you decide, the comparison between height and a setback encroachment? And that is a grounds for a variance. It's not a requirement that a variance be granted. It's an independent, in the absence of a hardship, it's an independent basis for granting a variance, but it's not a mandate that a variance be granted. But again, you'll look at the kind of the impact and the extent of the benefit to the neighbors, things like that. If there's nobody behind that house that I gave the example for, and there's a neighbor very close to the side, there would be a benefit to the neighbor to get rid of that staircase potentially, because people wouldn't use it, might not interfere with the neighbor's enjoyment of their property, and the encroachment in the rear may have little or no impact. But those are the factors you would consider in determining whether you would grant a variance on that basis, even in
So-
the absence of a hardship.
Thank you, Pete. So bottom line, folks, to grant a variance, you either need an established hardship, which is pretty hard to establish these days after the ENF case that we described earlier, or a reduction in an existing nonconformity. And Pete, let's clarify this. It can't just be any reduction to any existing nonconformity, right?
Right. Got to be comparable to the reason the variance is being requested. In other words, variance is being requested for a setback, encroachment into a setback, then it's a reduction in a setback nonconformity somewhere else. So it's you have coverage, you have height, and you could have a house, for example, that is non-conforming as to height, and you're going to reduce that height in exchange for maybe raising another branch or L of the house and getting that height a little bit higher. That would be, again, apples to apples. That's what we're talking about in terms of reducing nonconformities.
Jess, I saw your hand go up a couple times. You good?
No, I'm good. With respect to the trading off, so I think this has happened before where say there's like a non-conforming issue, like a prior shed or something that, people claim, oh, it's been grandfathered in or something like that. And if we say, well, they volunteer or we have them agree to remove the shed, but if it was for a height, then that isn't an appropriate, similarly situated request. If it's, removing a shed that's maybe in a side setback versus a height variance. So it would really have to be if they're trying to build further out on the house, say, or add a garage into the setback and need a variance for that, then saying remove this other shed would be the more appropriate exchange.
Right. Or coverage, for example, lot coverage. But in exchange, typically, unless the regulations provide, now the regulations in each town, the regulations may provide for a situation where coverage can be reduced and height can be increased. Then there's not a variance needed there because the regulations apply that. And one just quick point, when we say non-conforming, that means by definition that it predates the zoning regulation that would apply to it. I like to distinguish non-complying with non-conforming, because non-conforming has a legal, you don't have to say legally non-conforming, it's almost redundant.
Yeah.
In the days after ENF, and even through today, if there's any question about whether a hardship can be shown, there are experienced, land use lawyers representing applicants who will go down this alternate route if they can construct, the right scenario and the right argument as an alternative, as Nick was suggesting, to the hardship standard. So that two separate ways to go with that. It's worth mentioning to talk about the Anatra case, which was a Madison case back in 2013. And it actually did come up in another town just within the last few weeks. But the Supreme Court held, I'm reading from my notes here, that a variance that was expressly tied to a particular site plan in the file, it prevents the owner from, the way I read it, subsequently coming back and saying, well, I got a setback variance, so I want to do something else now, or go up another level or something. I got it already. But the concept is that the ZBA at that point, based on certain representations in the record, a site plan that showed this is what they wanted the variance for. It was granted for that purpose, and it doesn't necessarily apply to, any other kind of expansion or construction that might be within that same setback, let's say. So I think it can be an important consideration.
Can I jump in on that?
Yep.
For perhaps 3 minutes? So I have a real world example of this, everybody. Not through a municipal client, but through a private client. And it is literally this exact situation where we are opposing an approval that was granted over the counter of a town site plan that benefits from a variance that was granted 20 years ago. So, long story short, I will not spend any more time than we need to tonight, but there is a case that I have filed right now in the appellate court that is asking the court this very question. Just how far do variances attach? And how much do we actually need to give them credit under the law if there is no justification at this point? So a little distinction, but I think that's all to say there is still court cases to be had on this subject that will be coming down over the next year or two that I think will help us, plan forward. But this is still, from our perspective, a little bit of an open question.
I think the only point that you folks on the board should keep in mind is that this case is out there, and if you have a situation where someone, I guess this applies to administrative decisions, Sarah, also, someone has said, well, we got a variance, 10 years ago, 5 years ago, 20 years ago. Go look and see what it said, and what was in the file. Was there a site plan as part of the application, or certain representations as to what it was for? Because that may be a relevant consideration in the subsequent action. So I think that's the point of
Well,
this.
and the other thing that happened in Anatra, just to give you a little factual background of Anatra, somebody wanted to put a section of a second-story balcony into the setback. And the architect who designed it stood in front of the ZBA and said, if you grant this variance, we will never we won't expand the balcony anywhere else. And a few years later, they came back in with a plan to expand the balcony someplace else. And that part that they were expanding was compliant, was not within the setback. So they got a variance, then they wanted to add some more balcony. And the ZEO, who happened to have been at the hearing, said, wait a minute, you said you were never going to do that. It was actually a subsequent purchaser of the property. And the ZEO said, you said you weren't going to do that. So it wasn't a condition of the variance. It wasn't put into the variance, and it wasn't in the resolution that the ZBA granted, but it was in the minutes. It was in the record of the ZBA, and the court held that the subsequent owners were bound by that representation from the architect, even though it wasn't a condition of the variance. So there was no way for anybody who searched the land records where the variances are recorded to see that condition. And yet it was deemed to be a valid condition. So they were denied the right to expand their balcony, even though the expansion met the zoning regulations, because of the representation that was made to get the variance. And the court held that the ZBA relied on that representation to get the variance, and that reliance was deemed to be sufficient to be binding on not only that owner, but subsequent owners.
So
Who
I,
didn't even know it
you
existed
raise
because
sorry.
there's no way to know that. You know, when a lawyer does a land search, they don't go and look at transcripts or minutes of ZBAs. They look at what's recorded on the land records. So,
So the lawyer would know about it, but again, let's bring it back to, this board. How would you know about it, right? Somebody comes in, they say, this is what I'm applying for. Maybe they don't need a variance like that, Sinatra subsequent
yeah,
application. How do you find out about it? Who finds out about it? The
you
lawyers
probably wouldn't. You probably never
probably
would.
wouldn't unless, you took the time, I guess, to really go into the prior record, depending on what you have. Are you going to look at every transcript? Are you going to watch every video? I mean, if it's something right on the top of the file, that's a little easier, but it does pose a practical problem. How do you know what limits exist? Was there a site plan, like apparently in the Anatra case? I thought I saw. Maybe you said it was in the minutes, so maybe it was in the minutes.
It was a representation from an architect.
In the minutes. So you have to find the minutes to see what
Right.
was represented. On what basis was that prior variance granted?
Right.
And-
And it was only because the ZEO who was reviewing the
Remembered.
site plan remembered. Said, wait a minute, I seem to, that's not going to happen very often, but
A new person is not going to have a clue, and then,
Right.
records are destroyed, or you don't keep everything indefinitely. And so this becomes a potential problem. So, you do the best you can, I guess.
Yeah.
But it's something to keep in mind. And if you do have a record, it probably warrants going back to check it at least to see.
When we've made a motion in the past where it has been conditioned on how things have been presented in, say, the architectural drawings, which I guess would be similar to a site plan.
Mhm.
Is that enough where the office will then somehow attach that to the granted variance form? That if someone was looking back on the property record, they would see that, or at least see that referenced in to know that there should be some dated site plan to look at?
yes, that those typically a resolution should say as a condition of the approval, conformance with, plans dated, blah, 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 whether they're architectural or site plans. And when you put in the variance, conformance with those plans, then any deviation is not allowed or needs to go back to the ZBA to modify that condition, maybe with a new set of plans. If someone says, that's not really what I want to do, I changed my mind. Well, you got to go back to the ZBA because the variance initially was granted based on a specific set of plans. And the best way to ensure that that happens is to reference those plans right in the resolution. And then
And sometimes those plans get replaced, and that's where there's
Mhm.
some disconnect.
Or we haven't had quite final, and I think we've
Yeah.
set it conditioned on whatever's finalized with the town, for instance, the town planner. So I just want to make sure we're
No, you're
putting
doing
it
the
in
right
the
thing.
proper
Yep.
more, type of motion to make sure if we're doing that. Because I always get a little nervous if we're going to require screening or something, because I feel like that is one that's very vague in the moment. It can be hard for a future owner to understand what was being required of something like that, where there isn't necessarily a screening plan yet agreed upon or depicted somewhere. So it's hard for them to reference what's actually being requested.
I will say that for New Canaan specifically, I remember something about 2 years ago at this point where we got a call from a next door neighbor who recalled a variance where basically the next door neighbor he just purchased the home, was about to tear down some evergreen trees, and the neighbor called us in a panic and said, there's a variance from 2010, this screening has to stay. And then we were able, thankfully the neighbor remembered, but we were able to find the variance right away, and it clearly referenced the screening, and then we were able to call the neighbors, the new homeowner, and be like, hey, you can't cut down these trees. And Stephen and I were not in New Canaan in 2010, but we were able to stop that. So I think we have a relatively solid system going on internally.
Good. So, all right, well, that's good. you know, it's an important case and concept to keep in mind as you go forward and get subsequent requests. I think that I'm gonna, it's close to 8. I'm gonna just briefly talk about some more general topics such as conflicts and bias and predetermination, and you know, we do whole sections on that. So this will be sort of another summary. I'll start with conflicts of interest. You obviously want to avoid them, financial or personal. You know, what does that mean? It varies from situation to situation. You know, there are statutes that that talk about conflicts, personal and financial. You can't represent someone before your own board ever. You can seek a variance for your own property, but we talk, if that happens, we often suggest ways to sort of keep a little bit of a distance, you know, like maybe your spouse do it. You know, maybe there's a lawyer that could do it, just so there's a little bit of separation there, but you want to be careful about that. You do not want to go to other boards either, representing people, the P and Z, for instance. So that does come up. I've had situations where people were land use professionals and they're on one board. It was a wetlands agency, and they went before P and Z against my advice. This is a long time ago, and that caused a court case and an overturning of something, and it was a big problem. So you also want to be careful with the personal conflicts, financial conflicts. How do we define that? You know, some of it's obvious. If you're, you know, in business with one of the with an applicant, you know, you want to recuse yourself. What is a personal conflict? I mean, I have a whole list of examples of what a personal conflict can be. What if someone is a quote friend of yours? You know, how do you define friend? I mean, we could, you know, we have different levels here. I mean, a lot, you know, a lot of people, I'm sure, in the town of New Canaan, and I'm sure you know a fair number of applicants too. Just because you know someone doesn't mean you have to recuse yourself. If you tell me that, well, you know, we're golfing buddies and we, you know, and that kind of thing, well, you probably should. You know, so I mean, we can go on and talk about specific examples, but you do want to be careful, because otherwise you'll get some sort of legal action and we'll have to defend it. We
Ira,
are,
can I just jump in very briefly just to add on that point? I have had the opportunity to represent one of our towns who, as Ira suggested, we try not to, and it's unusual to see these types of claims, but we have seen them before. So I'll just reiterate, don't talk to the media about a possible any sort of application that may come in some form in front of you, whether it's starts at the P and Z and maybe there's some variance down the road that they're going to be looking for. Stay out of that. Don't talk about it. Same with the media. Like, the media will ask your opinions at the appointed times when they see things on your agenda. Just hold your comments, because
we'll
we
get to
have
that,
seen it.
Nick, the media, because it comes up in predetermination and bias as much as anything, but it's an important point to keep in mind. I mean, I'll just talk, let's just go right to that. You really should not talk, period, to the media. That happens, I think, less frequently now, where you'll get, you know, a call from a reporter at the New Canaan Advertiser. I hope at least. There was a day probably in the past where they might have done something like that, or call the chair or something like that. Sometimes they'll call you, Sarah, I suppose. I don't know if they're still doing that. But some time ago, they used to call me, you know, as the attorney, and that's kind of petered out a little bit. So, but now what people do is, you know, there's Facebook pages and other social media and blogs. And our advice is stay away. a lot of people are not listening to that advice, to be very honest with you. A lot of, P and Z members, I see it at planning and zoning commissions, I think more than ZBAs, but it's the same principle, and you just have to be careful. I advise not doing it at all. I had one situation very recently where I think it was a P and Z member in another town, and they were writing on, I think it was on Facebook, inviting people to come down, next week for this hearing, because it's very important and whatever. And, I said, don't do that. And the response was, well, we want to let people know that it's important and all that. Well, that's not a good idea, because that could show some bias, some predetermination. That member thinks this is particularly important. What about other applications? So it only can cause problems. And there are people out there that are looking to cause problems and create grounds for appeals. So social media, stay off. Newspapers, letters to the editor, probably doesn't exist anymore, but that was the concern, 20 years ago. Calls from the press, no comment. That's the best thing, because it could lead to predetermination, most likely, I would say, and that means you've decided your view on a particular issue. Doesn't come up, I don't think, as much with a ZBA, but it could, and it does come up with planning and zoning commissions, which have, a different task. So stay away from that.
HCCs, even, in my experience.
Yeah. That's kind of what predetermination is, where you are alleged to have decided already before you've heard the evidence at, during the public hearing. Bias is a different topic, but suggests that for one reason or another, you have some bias, some dislike, or some problem with somebody. And how would that be shown? I mean, some things are obvious. You're in the middle of a lawsuit with somebody who then appears before your board. You need to recuse yourself, or something approaching that. Some evidence that you've had some clash or don't like the person or support the person. So that happens once in a while. And if we are here to help, we answer a lot of questions. What do you think of this? What do you think of that? Do I have a conflict? Whatever. But all we could do is give you our opinion. You have to make the decision. And it's an individual decision. The board can't vote you off. But if you make the wrong decision, you're going to jeopardize the decision of the board, and it costs the town money. So you want to make the right call on it. And I usually say, if in doubt, sit it out. Don't cause a problem for the board. So that's a very quick conflict and bias and predetermination discussion. Happy to answer questions, or if Peter and Nick want to add on those topics, we can do that.
Yeah, the only thing I wanted to add real quickly, Ira, is it's important, and I'm sure I don't have to say this to the CBA, but it's important to treat applicants with respect, and especially when you're on the record, and you're on the record in your deliberations as well, to make sure that applicants are treated with respect and not have any derogatory comments about an application or an applicant during your deliberation or during the hearing. So we've seen that. It's doesn't occur very often, and I'm sure it won't occur with this board, but it's just something to be aware of.
Yeah, and without going into embarrassing detail, Pete, I know we're referencing a recent situation in an unnamed town, although it did get a lot of publicity ultimately. But some members of a planning and zoning commission just got sufficiently agitated and said some things that were probably inappropriate, and it caught the attention of the appellate court of the state, and the case was sent back. So I agree, it's rare. But sometimes, you know, you get frustrated or whatever the motivation or reason is, but you gotta just hold back in our business.
According to one of the appellate judges, the board or commission used very bad language. That's a quote from one of the appellate judges, very bad language. So anyway, that's to be avoided.
Questions? We're you know, not in any rush if you have more questions. You know, take a look at the materials. We were half joking and half serious about the Varillo case. It's very long, but it does have a you know, very good summary of what you do as a zoning board of appeals. And we're here. I'll throw in a plug for the Connecticut Bar Association P&Z section seminar for municipal officials, which is March 25. I'm pretty sure it's on a Saturday. And I'm a speaker there once again. Nick's been heavily involved with helping to prepare and is very active with the Fairfield County Bar Association, also doing similar things. But I would invite you to sign up for this Saturday seminar. It's remote, you know, it's a remote Zoom seminar all day. And it covers some very important topics. So,
And it's been going for what, 10 years now, Ira?
over 20. It's
Yeah.
every 2 years. I mean, I started in the early 2000s. We used to do it in person at Wesleyan with a seating capacity of, I don't know, 300 or 400 or something. We now do it online. I think we had between 900 and 1,000 people 2 years ago. So it's very popular. It's very useful. It gives you some of the credits that you need. It's fairly inexpensive. Some towns pay for it. Some towns don't.
Yeah, I'll just add in that we will make sure to send out the information to you all this week for it, and depending on interest between ZBA and the Planning and Zoning Commission, we likely can cover your registration fee. So keep that in mind, and just we'll forward it. But if you have interest, just respond to the email that we send out.
Thanks, Ira.
Thank you. Anything else?
No, this has been very helpful. Thank you.
You're welcome.
Okay, well, thank you all for coming on, and you know, if there are further questions, I think you can probably just send them over to Sarah, and she'll give one of us a call or an email, and we could, you know, get back to you on something if something comes up after.
If we do
So
have
thank
any future questions for you, is it best to direct them through Sarah?
Yeah, that's the preference,
Yep.
I believe, for the town to just go through me.
Okay.
Yeah,
Thank you for your time.
Our pleasure.
Thanks,
everyone.
Sarah,
Alright.
for organizing.
yeah.
Yes.
Thank you, Sarah, for helping. And
Yes.
Thanks, Sarah. Thanks, everyone.
okay, have a good
Thanks,
night,
it's great.
everybody.
Have a good night.